All right. Welcome to a United Policyholders Roadmap to Recovery webinar. This is a special webinar with special guests on a special topic. Our audience is people who were affected by either the 2017 fires we call the North Bay fires. That would include the Atlas, the Tubbs fire, the Carr fire, and then the 2018 fires up in Chico, so the Paradise, or Campfire rather, in Paradise. Sorry. Okay, so those are the two areas we are focused on disseminating information for. If you are watching this webinar and you were affected by a fire other than the 2017 North Bay or the 2018 Camp Wildfire, you're more than welcome to shoot us an email and we can certainly try to connect you with similar expertise. But we are focused today on compensation for those two fires for losses not covered by your insurance. And I want to tell you briefly about United Policyholders and then introduce our panel. So we are a not-for-profit 501c3. This webinar is free. It is for anyone who owns property, was insured, and had a loss. Our organization is chartered as a nonprofit educational organization, and we've been around since 1991. Our focus is on disaster recovery. We are funded by donations and grants, and our work gets done by a small staff and then an amazing core of volunteers that includes attorneys, professionals, survivors, people who've gone through a loss, have a lot of information now that they've heard the hard way that they then want to share with other people. So we have all those three categories on the panel today. We partner. We've been partnering with Butte County up in the Campfire recovery and Sonoma and Napa with the 2005 recovery because it takes a village. So we are very pleased to be able to bring you this information today. It's part of one of the three programs we run, the Roadmap to Recovery, through which we help people solve insurance problems after disasters. We also do advocacy and we do preparedness work. Through the Roadmap to Recovery, we give people an orientation to what it's like to go through a major insurance claim after you've had a catastrophic loss and how to navigate that. And then we provide, during the long-term recovery, series of workshops, clinics, and different events that help people make decisions and just get through. And we do provide emotional support through people like Jim Finn, who's with us today, again, who've been there, done that, and are here to say, you're going to make it through. I'm sitting or standing right here in front of you, so that's proof that you will make it through this horrible, daunting process. We also provide financial decision-making in partnership with financial planners, CPAs, lawyers. We work with the Department of Insurance. We provide online and print guidance. We do surveys, and we do advocacy in the California Capitol when need be, other capitals, and a bit in Congress as well. Why are we here? The facts. Insurance funds are critical to recovery, but most loss survivors are underinsured in at least one category. Our latest surveys from the North Bay were that people had an average of $300,000 gap in their the difference between how much insurance coverage they had and how much they actually lost financially. So we know that. We also know that 2 years of temporary rent benefits are not going to last a lot of people. So in other words, people are getting cut off today in the North Bay, and that means they're going to have to go a year unless their insurer has agreed to extend their temporary rent. They're going to have to go a year paying their temporary rent plus their mortgage unless they can get back into a replacement home sooner. The folks who are watching from Paradise or Magalia or wherever you are, obviously that's not as big a concern, but still, insurance does not cover all the damages a disaster causes. It's not going to compensate you for your emotional loss and the financial losses that either were not covered by your insurance or for which you didn't have enough insurance. So that is why we're here today. This is just a screenshot of the landing page for where you would go to file a claim online with PG&E, which is the utility in those two regions, the Butte County, Sonoma, Napa regions that were affected by the 2017 and 2018 fires. And the facts are that PG&E has responsibility and for the losses. I'm not going to go into any more detail on that because I want to leave that to the experts on the panel. So I want to welcome James Finn, Tubbs fire survivor, concerned neighbor. Jim, do you want to just give us your quick intro to who you are and why you're on the panel?
Oh, of course. Thank you, Amy. And I also want to thank Matt and Elizabeth for attending as well, because we're all kind of on the same team here. I got the opportunity to run away with my life barely at 2:45 in the morning from the Tubbs fire in Fountain Grove. And then, of course, discovered that virtually everything I owned was lost. And then got the opportunity to suffer a second trauma when I started working with my insurance company, unfortunately. And that's where United Policyholders really came in and helped a great deal. So this is almost at the 2-year anniversary, and I have concluded settlement talks with my insurance company, and that didn't have to involve a lawyer, fortunately. And so I'm just getting around to deciding whether I'm going to rebuild or buy a new home. I'm here because I have been on the front lines of experiencing the tremendous amount of misinformation that has been out there floating around about PG&E's bankruptcy. Initially the lawsuit and then bankruptcy. And I've actually been involved with a small group of folks that have been very active in trying to educate our community. We're all from the North Bay fires, so we don't have anybody in the Camp Paradise area, unfortunately. However, we have been holding meetings. We're having another meeting with the Coffee Park on Thursday and doing outreach events like this. The amount of misconception out there among people is huge. They don't understand about the realities of this bankruptcy and their rights regarding it. And I'm doing this because I know personally what it's like after you go through a loss like this. I realize how much insurance can underinsure you and how much of a shortfall there is in the finances. And I understand the truths about the bankruptcy and that the recoveries could be quite substantial for people who have had major losses, and even for people with partial losses. So I'm here to help people now just file a claim, because we're really getting pressed for time. And the deadline is October 21st at the end of the day, 5 p.m. Pacific. And you can fill the form out that's required with help. We're willing to help you, and I'm sure there are other attorneys here that are willing to help you. And you can do it actually without joining an attorney group at this time. Later, after you do that, you can, in fact, if you decide you need help sorting through your claim, you can join an attorney group after that. But we want to help you, number one, fill it out before the deadline, because if you don't, you lose any opportunity after that to claim against PG&E forever for these fires. And second, we want to try to help you fill it out as accurately as possible. For that, we have actually established a website on our own, as well as with the help of United Policyholders, but this is a project on our own, the pgefireinfo.com. And we have also a email, contact@pgefireinfo.com. And we have folks that are experienced in answering questions about filling out this form, and we're happy to help people do it properly. But right now we're running up against a critical deadline, October 21st. So thank you, Amy.
Okay. If everyone can see right there on the screen, October 21st at 5 p.m. Pacific, hard deadline. Our next speaker, I want to introduce Elizabeth Cabraser. Elizabeth, it's such an honor to have you with us. You've been a hero of mine for a long time, and I know that you have been very much in this with your sleeves rolled up now for quite some time, and you were at a hearing this morning. So Elizabeth, just give us a little intro of why you agreed to be on the panel.
Absolutely, I'm pleased to do that. But first, thank you to United Policyholders. This has been a fabulous organization since 1991. It's been helping policyholders of every kind, particularly after fires and earthquakes and other disasters. And you've helped people navigate through the thicket of insurance claims and recovery. And for that, you have my thanks. I'm a lawyer by trade. I've been practicing for 40 years, and I focus on representing plaintiffs. I represent plaintiffs only in all sorts of mass torts, class actions, environmental cases, financial fraud cases. But here, the impact is much more personal. I've also been a proud resident of Sonoma County for 40 years. I was very lucky. My home was spared. Many of my friends and neighbors were not so lucky. And I got a very small taste of what it is like to personally go through a disaster of this magnitude. I'm used to being someone who feels empowered in the law, but I have to say that the feeling of disempowerment, the feeling of depression, the feeling of helplessness, the overwhelming nature of just having to go through daily life after a catastrophe like this can be truly daunting. I had seen it happen to my clients over the years. I had never even experienced a taste of it myself. And this time I did experience it in some small measure. So first, thank you to all of those fire survivors who are helping themselves and each other. Jim, thank you so very much. My main message today is the one that you're going to hear over and over again that I hope everyone internalizes. And that is that bankruptcy claims must be received by October 21st, 2019, by 5 p.m. Pacific time, in order to be assured of consideration in the PG&E bankruptcy. This is called a bar date, and it is one of those draconian measures utilized in bankruptcy court to make sure that claims are limited. The system is set up to limit claims. The system is set up to erect barriers to claims. These barriers can be overcome here. The good news is that the proof of claim itself is relatively straightforward. It's relatively simple. Many attorneys, many members of the Tort Claimants Committee in bankruptcy were personally involved in making sure that this wasn't a 10 or 20 page claim form. It's a 3-page claim form. We tried very, very hard to make sure the language was clear and plain and unambiguous. That said, it's a form, and forms can seem intimidating. Our message today is that for those who were insured, you were almost certainly underinsured. For those who weren't insured, there are claims you can make. Insurance simply doesn't cover all of the qualified losses that can be considered by the bankruptcy court in paying victims. And you see some of those on the slide there. They include the obvious things like property loss. They include evacuation damages and relocation expenses. If you were under an evacuation order, and you had to get out of there, all the costs of doing that, all the costs of trying to survive somewhere else are compensable. Emotional distress is compensable. And that doesn't mean that you have to be permanently disabled or you have to see a counselor or a psychiatrist. The experience of going through the evacuation, the displacement, the catastrophe of dealing with the aftermath is recognizable by the law. Injury to your livestock, your pets, in damage to trees, agricultural losses, loss of wages, business loss or interruption, whether you owned a business or whether you worked at a business that was disrupted or closed by the fires. You have a claim. You should not be shy about filing that claim. And Jim is right. You can do it without a lawyer. For claims that are complex, yes, we do recommend that you contact a lawyer, and there are many lawyers to contact. You can also contact a lawyer after you file your claim to amend it, to add detail, to correct it. The main thing is, by hook or crook, get that proof of claim form on file by the 21st of October. That's the most important thing, and that's, I think, the most important message that all of us have for fire survivors today.
Okay, very helpful. We'll get into more detail on that, on just how little detail you can actually put in. Matt Welty, another good friend of his community, another longtime Sonoma County, I think you're native resident. And Matt, I know you're right there with neighbors, and tell us about why you thought it was important to be on the panel today.
Well, thank you, Amy, and thank you, United Policyholders, for all the reasons that both Jim and Elizabeth said. You guys are doing amazing work, and it's just an honor to be kind of a part of it. 15 years ago, the room I'm sitting in right now burned because our building was subject to an arsonist. And we had to adjust a fire claim, my family and I did, and we kind of knew what it was like at that point to go through the insurance process. So 2 years ago, when the fires occurred, and we have had a practice in Sonoma County for 40 years, we have quite a number of local clients. Our phone started ringing asking for help, and we knew what it was like to adjust an insurance claim. Even when we had the sophistication of a law practice at our back. And through that process, we kind of were dragged into a little bit unwillingly, because of our clients just pleaded with us to assist them in every aspect of their claim, including what relief they had for underinsurance or other compensable issues that Elizabeth already spoke to that were not going to be covered by their insurance policy. And so as a result, we decided to participate in this litigation against PG&E as well. And as a result, developed a working knowledge of everything that's going on. And a year ago, my own family members ran for their lives in the Paradise campfire. So yet again, it was an opportunity to sort of work side by side with those victims, help them with their insurance process. And I'm just honored to be here and to be a part of this as much as I can help not only my local fellow community, but also our cousins in Paradise. We're happy to do that.
Well, thank you all. And there's no slide about me, but I'll give you just a quick, my background is I'm a professional insurance consumer advocate, which means that since 1984, I have dedicated my time in the working world to understanding as much as I can about the insurance system, how it works, how what the consumer needs, and then I co-founded United Policyholders, recognizing that insurance is a very important product because we have to buy it, right? We have to buy it if we have a mortgage. We have to buy it if we want to drive legally. And therefore, so being as we're sort of captive having to buy this product, and it's a very opaque product, meaning it's not transparent, right? You buy a policy, you get it, you don't know what's in it. I recognize that the consumer really needed a place to go that they could trust to get information about insurance from somebody that was not trying to sell them something. So that's kind of, again, United Policyholders, we try to stay in our lane and educate people about insurance. But because we do so much work in the aftermath of disasters when insurance is so critically important and people are really trying to collect every dime of benefits that they can because they need the money. We have come to see that when you're in a situation like the 2017 and 2018 fires, where there may actually have been something that caused your losses that wasn't just an act of God, it wasn't a bolt of lightning, but it actually could be somebody's wrongdoing, and somebody who has insurance and has money that could compensate. We, as part of the Roadmap to Recovery program, as part of educating you about getting full compensation from your losses from insurance, we also want to give you information about getting compensation from a source that had some responsibility for the loss. So that's really why we're trying to bring this to you, because look, you know, we've been doing workshops in downtown Santa Rosa for 2 years, and we've been doing them in Chico for a full year almost now. So I'm very in touch with a lot of people. Our whole team here is in touch with a lot of people who've lost homes in these areas. So we're hearing all these rumors that Jim was talking about. And I have been trying to assure people now for quite a while that, you know, pursuing compensation from this PG&E claim process is kind of a no-brainer, to be honest, in one sense, meaning it doesn't cost you any money. You don't have to hire a lawyer even to participate in it. And it's really almost no lose, except for that I recognize the emotional condition that so many folks are in, understandably, of being just tired and just really wanting it to be behind them and thinking, oh, a claim form, a lawyer, a damages, what, I can't, you know. And I really get that. And the reason we're bringing this to you today is, you know, we went to 3 people that I feel are trustworthy, that really know the lay of the land here. They're not here to get you to hire them. You certainly can. The 2 lawyers that are here, this is what they do. So you get off of this webinar, you can get in touch with one of their firms. I'm not here to steer you there or not. But what I'm trying to tell you, if you have had these losses, we're bringing this to you because we really don't want you to leave money on the table if you can avoid that. And so one way of not leaving money on the table that could really help you get on your feet is to file this claim. And that's why we're doing this, okay? It's a little out of the insurance realm, but it's about your road to recovery. So I'm going to go through now some of the questions that we got from your communities. And we're going to have the panelists answer. Okay, I thought the proof of claim was for those who hadn't joined a class action suit, or for those who had limited funds and had not started to rebuild. Let's start with Elizabeth. You were at the hearing this morning, and yes. Figured jump right in.
That's false. So many folks have, one way or another, filed their own cases, individual cases or class action suits in underlying litigation that was filed before the PG&E bankruptcy. The PG&E bankruptcy trumps all of those. Everyone needs to file a proof of claim. That is the presumption. If you have a lawyer who's filed suit for you, check in with your lawyer. Your lawyer should be in the process, if they haven't already, of filing that proof of claim. But do check in. Make sure that they're doing that. If they need additional information to do that for you, provide that information. It may well be that some of the proofs of claim are ultimately allowed as class proofs of claim. I have filed class proofs of claim, but I am not counting on the court doing anything because we just don't know. No criticism of the court. We don't know how that's going to come out. So right now, there is an opportunity for people to stand up for themselves, to file their own proofs of claim, to do it on their own, to do it through their lawyer. That is something that you can do. You may well, need to do that. And certainly you need to do that to protect the presumption that you will be able to get paid on your claims. So don't assume that you're in a category of folks that just don't have to do it. Check with your lawyer. If you don't have a lawyer, go to the claims portal, go to the PG&E wildfireinfo.com, take a look at the proof of claim form. Fill it out yourself if you can. If you don't feel able to do that, contact an attorney to help you.
Okay, so we're not going into the whole history of how there ended up being a bankruptcy proceeding, but is it a fair Cliff Notes to say that there were a lot of lawsuits filed against PG&E arising out of these fires, and not just by individuals who lost their homes. And so then the company filed for bankruptcy, and then all the lawsuits got consolidated and put into a bankruptcy proceeding. So it sort of changed it sort of channeled all these lawsuits into one place. Is that right, Elizabeth?
That's right. Bankruptcy is a game changer, but there's something important people have to understand about bankruptcy. Bankruptcy doesn't mean that PG&E doesn't have to pay claims. Bankruptcy simply means that there's a new procedure, which is the exclusive procedure under the law that is used to determine how much PG&E has to pay to victims and whose claims will be allowed or approved. So it's a new procedure. We follow the rules in the bankruptcy procedure to make sure that the proofs of claim for the victims are allowed. And the fact that there's a bankruptcy, the one message I would say, the fact that there's a bankruptcy doesn't mean that PG&E is broke. It doesn't mean that PG&E isn't responsible. It doesn't mean that PG&E can't pay or shouldn't pay. It's just a specific procedure to channel all of those claims. So if you have a claim for anything that is uninsured, underinsured, doesn't qualify for insurance, arises out of what you experienced or spent or what you are dealing with now as a result of any of these fires, you are absolutely entitled to file a proof of claim. That is your right. There's a deadline that goes along with the exercise of your right, but that is your right to do.
So, okay, Matt, I'll tell you, one of the reasons that I said, okay, let's pull this webinar together. Obviously, we're concerned about the deadline, but I was hearing that there's quite a bit of money available potentially in this bankruptcy proceeding, and that a lot of you who've been working on this have been working toward that for a while. So if somebody is already signed up in a lawsuit, should they still file this claim, a proof of claim?
Yes. I think Matt will agree with me here. Yes. But as I say, if you are in a lawsuit that a law firm, your lawyer has filed for you, again, check with your lawyer. That proof of claim should be on file through that lawsuit. I'm not saying you have to go back and renew and replicate the process, but somebody, your lawyer, needs to be filing that proof of claim for you. And there is a system through which all of the underlying litigation, the complaints, the claims, and the underlying litigation is being transferred to the proof of claim system. But again, you need to make sure that you are included in that process. And as I say, check with your lawyer. And that goes for all types of claims, including the claims for wrongful death and personal injury, as well as business loss, business interruption, property damage, home loss, economic loss, lost wages. All of those categories we're talking about, those are the categories. If you take a look at the proof of claim form, there are boxes to check for all of those. So those are all included in the form. They are all potentially compensable. But as I say, the common denominator here, the prerequisite to make sure that your claims are considered is the proof of claim form itself.
And can I just say one more thing, adding to what Elizabeth just said, which is that almost every, if not every PG&E customer in the state of California received a claim form, but it was not fire related.
Right.
It was for other claims that were not related to the fire. So if any of you are out there watching this and want to make sure that you're looking at the right claim form, the top of the form will say proof of claim, and then in a parenthetical next to that, it will say fire claim related.
Yep.
That is very important that you file the right form because it also requires you check the right box to the fire that you're claiming your claim is related to. But beyond that, at the bottom on the last page of the instructions are the mailing information and or the actual physical address by which you can hand walk in a claim. So you really want to make sure that you have the right claim form and then you follow those instructions if you're trying to do this yourself. But I do agree with Elizabeth that, you know, as a lawyer, this is complicated, and if there are any questions, you are well served to contact a lawyer.
Okay.
Can I dovetail on them?
Yeah, hang on 1 second. Before I jump back over to you, Jim, this screen that I've got up right here, I see this is the PG&E, the prime clerk. This is the basic page, correct? Where you actually submit your claim.
Yes, they want to make sure you are not a robot.
Okay, and so you see down here it says fire claim bar date October 21st, right? Okay, so and then right under that, wildfire subrogation bar. We're going to talk about that later. But Matt, the question I had been asking was if you'd already signed up for a lawsuit before, if I got this right, what Elizabeth is saying is, don't just assume that that your lawyer has filed a claim for you in the bankruptcy, correct?
That's correct. I would agree that you would contact the lawyer that you believe has already filed a lawsuit claim for you before the bankruptcy proceedings were initiated.
Right.
Verify that they have then in turn filed a proof of claim in the bankruptcy proceeding. And I recommend that you get that verification from your attorney in writing.
Okay. Okay, Jim, did you?
Thanks. I wanted to dovetail. Could you go back to the prime clerk screen for a second? So there are two things on here I wanted to point out, and this is from the point of view of a non-attorney, a retired physician. So I never been sued, so I don't have any experience in this, but from a claimant's perspective, if you can you take your mouse and bring it over to the box on the far right side?
This one?
And go over fire claimant proof of claim. So
yeah, hang on 1 second here. Let me can really get creative. Let's see. We're gonna do. Well, I don't know if I'm gonna be able to do that. This is a static shot of the.
Yes, that's a static, but it's going to show your mouse, right?
Here.
Mm-hmm.
Okay.
There
we
we
go to the right side and just point on fire claimant proof of claim.
There we go.
That one. That's the one. Now that's the PDF form that you would print out. And then as Matt stated, there are a listing at the bottom of the page of either mail-in places, which we're getting awfully close to the deadline to do that. And you also have to submit an additional copy for your records that they return, or you can walk it in, as he said, or you're staring at an online submission form, okay? So the creditor name, the email address, you can actually file it by online submission. This is the fastest way. It's a series of questions that are the same as on the PDF form. And at the end of it, it will give you a claim number. Also, you might want to ask for the claim number from your attorney if they have filed it in your name specifically. And you can look it up on this site under, I believe it's under the docket or under claims. It's under the claims tab. I'd have to double check that. But so you can confirm it yourself after you talk to your attorney.
Okay, great.
Right.
So we're talking about.
And by the way, if you are the person making the claim for your own losses or costs or claim, you are the creditor. The very first question on the claim form says, who is the current creditor?
Okay.
That's
all
you.
right. Okay. All right. So unlike in a lawsuit where you would be the plaintiff if you're suing or the defendant if you have been sued, in this proceeding, you are a creditor
That's right.
because that's how bankruptcy law works.
That's how bankruptcy law works. You are the creditor. PG&E is the debtor. That simply means PG&E is the one that owes you your money.
Okay. So now, Jim, obviously, a lot of people who are dialed and watching this when we publish it will have been following in the news because they're impacted by all this. The CAL FIRE reports and the back and forth over the last 2 years as to whether or not PG&E was responsible. So some people, again, rumors. Are survivors of the Tubbs fire eligible for these claims, the same as an Atlas fire survivor, for example?
My understanding, my attorney, who's Greg Skikos, has told me yes. There's a couple of things going on. One is that Judge Montali, the bankruptcy judge, has gone ahead and allowed a rather unusual situation, which is a state trial for the cause of the Tubbs and to determine damages for a very specific group of plaintiffs. There's a small group that has the right to a priority trial because either they have an illness or they're old or something like that. And it's currently scheduled with Judge Terry Jackson in Superior Court, San Francisco. I believe the first day is going to be January 7th, 2020. Right. But there's another line of evidence that the Tubbs is fully going to be recoverable, and that is that in the offer that PG&E made to the subrogation claim holders, so in other words, to the insurance companies, to your insurance companies, the Tubbs fire was not discounted at all. So that a priori would be evidence that the fire claimant should receive the same treatment, and they're going to have a lot of explaining to do if they don't want to do that. Now, I'm not an attorney, and I don't have a feel for Judge Montali like Elizabeth does or Matt does, but I think that these things are important considerations. And also, if you have any question as to whether the Tubbs fire was started by PG&E, I suggest going on to NBC Bay Area, their videos and their articles, which has a wealth of information about the evidence that's available. And I already thought something was a little funny about the way CAL FIRE presented their findings just before PG&E declared bankruptcy. But after I saw the video evidence on NBC Bay Area, I became actually very concerned that CAL FIRE had missed something. So that's where it stands now. But I would have confidence Tubbs fires. I mean, I'd leave that all. I'd also ask Elizabeth and Matt about that as well.
Yeah. So Matt, hang on one sec. I just because this has been, there was the back and forth. Yeah. Just to keep it simple for the viewers here. So regardless of which fire, whether it was Atlas, Tubbs, Camp, Carr, we still are encouraging people, if they have losses from one of those fires, that they should put this claim in if they live in an area that's—
Absolutely. Yep. Absolutely. The bar date is the same for all fires.
Okay.
It is the same for 2017. It is the same for 2018. Okay. If you have a claim arising out of the Tubbs fire, don't wait to find out how the Tubbs fire trial goes. We won't know that until February or March of next year. What we do know is that the claims bar date applies to Tubbs fire claims. The court will sort out, right, which claims are compensable. But again, if you're not part of the claims program, if you haven't filed your proof of claim, you're losing an opportunity to be considered for compensation. And that's what's important now.
Okay. So Matt, if you see that middle question, I understand that you don't have to hire an attorney to file, but am I in a better position to recoup my losses if I have an attorney represent me rather than filing the papers myself? That's kind of a softball question.
Yeah, thank you.
Lawyer, I didn't write the question. If you could take a crack at it.
Well, I believe that proving the claim is your claim is unique to you, and the damages you suffered are unique to you. You have different damages than even your next door neighbor. And therefore, to properly support your claim for compensable damages, as Elizabeth just touched on, the various categories, you are going to need somebody to assist you with some technical expertise on how to properly support your claim number. And when I say claim number, I mean actually the dollar amount of your claim, the value. The form that you file for the proof of claim in the bankruptcy court allows you the option of saying that you decline to say the amount of your claim's value, and that you will determine that at a later date.
Mm-hmm.
And it's for that reason that having an attorney will be most likely an advantage more than not, to be able to properly document and support your claim number, dollar amount.
Okay. So okay, we're going to get into a little sensitive area here. So obviously hiring an attorney means you got to pay some fees or pay a cut. So I think what a lot of people want to know is, am I better off filing this claim on my own without obligating myself to pay a lawyer and sort of taking my best shot on my own, or am I better off paying a professional a fee? Is it going to even out? Elizabeth, can you give us some thoughts? And Jim, I'd love to hear yours as well.
I want to hear the doctor talk about operating on
Yeah.
All right, let's go with Jim first. Yeah. Can I have an RN do my surgery? No, I'm kidding. That's true.
You could. Good luck. Look, I'm not here to disagree with that. Actually, if you have a complicated enough claim, or you have, for example, a wrongful death claim, you should use an attorney. Okay, that to me is pretty basic. It also depends on how comfortable you are with this. If you're not comfortable filling this out, if you're confused by that, even this claim form, by the way, is simplified. It's what Elizabeth said. The TCC, the Tort Claims Committee, went to a lot of work to insist that it was simplified. And it could have been really horrible if PG&E had its way. It would have been very intimidating. So if you're not comfortable filling it out, please seek the help of an attorney. Now, the only issue is at the moment that we are really coming up against a deadline. And some law firms are actually starting to turn away clients because they can't handle the capacity. I don't know what Matt and Elizabeth's situation is. I know Greg will take people up to the end. So I'd like to hear what they're doing. But if you're not comfortable with it, use an attorney. The fees are going to be only paid if you get a recovery, and you will get a recovery in this bankruptcy. You will get a recovery. And it's generally worth it. You know, we could debate on what the proper percentage is and what caps should exist for the expenses. There's also another possibility I want to alert the claimants about, is that in a bankruptcy of this size, it's not entirely unusual for the judge simply to set what the limit on what attorneys can collect, and actually form a separate trust or pool for that, what I'm told. So that could happen, not a guarantee. But I think if you are not comfortable or your things are complex enough, please use an attorney.
Elizabeth, did you want to comment on that?
I think that's correct. This is not a bankruptcy that is comprised of creditors that are used to being creditors. Banks, businesses are used to filing proofs of claim in bankruptcy. That happens in the normal course of their business. There may be some small business owners among the fire survivors that have had to do that themselves, but most of us have never had this experience of being a creditor. So I would say this may be something you can do yourself if you have a simple claim. It may be something you need to do yourself if you're coming right up to the deadline. But if you have an opportunity to discuss this with an attorney, that'll help you become more comfortable as to whether this is something you want to do on your own, at least to start, whether it's something that you want to have a lawyer help you with. Jim is correct. The firms represent claimants on a contingency fee basis. That's regulated by California law. It's negotiable. It's a transparent process. Don't let the opportunity to contact an attorney, a local lawyer, someone who specializes in this case, whoever it is. Don't hesitate to contact them and at least get information from them, and at least ease yourself into this process. And then whatever works for you. Again, the most important thing is between now and the 21st is to get your proof of claim on file and protect your rights.
Understood. Okay. We're going to try to jam through here. We got a lot of questions, so we're going to just do our best, and then we will, as I said, when we publish this, we will add links. We will add the link that Jim gave us. We will add the link to Extinguishing Uncertainty, Up from the Ashes, and Matt, if there's a site that you think has got some good basic info. But I think I'm getting a very strong feeling here that given the substantial likelihood that there is definitely money there to pay to people, that no question you're better off getting something on file. And since you have, if you're going to do it online, you have a couple of weeks. It's worth taking your best shot from the get-go. That's my feeling. Because now, I don't know, Matt, is your firm still taking cases?
Yeah, we sort of anticipated that there might be a last-minute rush, and so we worked very diligently to file all the claims that we've had and processed with enough time to absorb some of these last-minute people that might come in. So we are taking on new clients as they come in.
Okay, Elizabeth, same?
We're happy to answer questions. We're happy to be retained if that's what folks want to do. Again, we know there will be a last minute rush. That's just the nature of a deadline, but we urge people to try to get ahead of that if they can. It's just for your own peace of mind to know that you've done it.
Right.
Amy, can I just emphasize that you can always retain a law firm after you file on your own. So if you are a last minute person and you do an online submission or you walk one in, and then afterwards you go, wow, I don't know what I'm doing. You can sign up and you don't have to worry about it, but you got to sign up by October 21st.
Yeah. Jim is absolutely right. If that's what happens and that's how you do it, that's fine. It's better to be in, even with something that is incomplete or imperfect, you can amend it. And I would just make a plea at this juncture. If you have friends, if you have neighbors, if you have community members, and you believe that they have not filed a proof of claim, please do spread the word. Neighbors help neighbors on this. Make sure people are aware of it. Make sure that they have the information that you have. Everybody out there, from the tort, including the Tort Claimants Committee. By the way, you'll hear a lot about the TCC or the Tort Claimants Committee. That's an official committee of tort victims that was appointed by the U.S. trustee to represent all of the tort claimants in the PG&E bankruptcy. It's an official committee. It negotiates with PG&E. It negotiates with the other creditors groups. There are 11 survivors, the people themselves on that committee. They have various lawyers. I serve as attorney to one of those tort claimant committee members, Angela Liu, who lost her father in the Paradise Fire. So they're people from all fires. They're people with all claims. They are your voice in the bankruptcy. They do a lot to ease the path for the tort claimants, and it was the TCC that negotiated this proof of claim form. One of the things the TCC is doing in its official capacity, and we're kind of the ambassadors of that, is to make sure that the consciousness and the awareness is out there over the ability, over the right, over the opportunity to file a proof of claim and the deadline.
Okay. I jumped ahead a little bit, listening to your answer, but trying to, I think people have had a lot of questions about, well, I either, I don't, maybe can I replace my lawyer? Here's one. If we've already signed on with an attorney, how do we fire them and file our own claim? Do we still have to pay the attorney? I mean, I think these are kind of, people obviously have some confusion about there maybe being two processes. Can we reassure folks that all, as long as you file a proof of claim by the 21st, you can deal with, wrapping up what may have been happening in a lawsuit before they all got stayed in the bankruptcy? This is going to get confusing. What I'm trying to ask you is, the people who had already kind of gone down the road with a lawsuit, they hired, let's say you're a 2017, you hired somebody early on, maybe they're a firm from out of town. I don't know if you have all noticed, but all of you are local. I do have kind of, as a consumer advocate, I always will, if there's somebody local, that's always great, especially if they can be paired with, so if they don't have expertise and they get it, from outside, that's fine. But if somebody is, hired somebody from Louisiana or Texas, and they haven't been hearing from that lawyer, and that litigation has been going on, and they don't know what's going on because their lawyer hasn't kept them informed, is that something they should be worrying about now, or would you just say get the claim form in and then figure out whether or not you're being well represented? Matt, you want to take a crack at that?
Well, I think that it is important to first focus on the claim deadline. Make sure that is not missed in any event. So whether you're with a lawyer you don't want to be with anymore or not, make sure the claim is filed by October 21st
Right.
at 5 p.m. That's issue number one. But in California, clients can hire and fire lawyers whenever they want to. And so there's a process for that, and it may mean that a lawyer may have the ability to claim part of their fee as a result of the work that they did in the claim up to that point of termination of the relationship. But there is a process to do that. So it's not advisable if you feel like your lawyer has been in communication and you understand what's going on, but it's your decision as a client.
Okay. Elizabeth, here's a question concerned with attorney's fees. This person is asking, we heard that lawyers are negotiating their fees in advance. Does that mean that the lawyers could potentially get paid twice? Can you address that?
Sure, and I'm not aware of any, negotiation of attorney's fees with the court. It sometimes happens in very large cases, including mass torts or class actions or even bankruptcies, that the court takes control of the attorney's fees. The reason courts do that, though, is specifically to eliminate the problem that this question is concerned with, which is that no, lawyers don't get paid twice for the same work. That just does not happen. It's called double dipping. Courts prohibit it, and what the court would be concerned with is just making sure that overall there is proportionality between what is going to the victims themselves and what is going to their lawyers, and that's why California law provides that contingent fees are negotiable between lawyer and client, and that's why you have the right to talk to your attorney and to reach what you consider to be a fair fee for service.
So, this is something that United Policyholders spends time on trying to educate the public about what a contingency fee is. A lot of times, we'll go into a community where there's been a disaster, and there'll be people who are, especially, when we go 6 months past the fire, where, the honeymoon period is over, the adjuster might not being as nice, friendly, and then, we'll get some people that clearly do need an advocate in their court, and we'll say, well, you can hire a lawyer on contingency. You don't have to pay a lawyer by the hour if you have been treated unreasonably and somebody has harmed you and there's quite a bit of money at stake. Well, Jim, was it hard for you to understand that you could actually hire a lawyer basically for free?
It wasn't hard for me, but I can assure you it's hard for a lot of my neighbors and a lot of loss claimants. It's something they don't understand. They assume I'm sorry, it kind of baffles me. They assume they have to come up with cash in advance to pay the attorneys, and that they're going to get billed what sounds like on an hourly basis. And, their eyes light up when you tell them, no, you only pay them when you get paid. And I try to explain the details of it, and also the concept of, why certain times attorneys' fees are very high, and how that's justifiable in a circumstance where attorneys are taking a risk. An attorney may, elect to take a case that's questionable that you have. I'm not talking about this bankruptcy, and that might have to go to court. The attorney will have to expend a lot of resources on it, and they may lose. So in those cases, attorneys charge more, and I think it's reasonable. A case like this if you're entering it on the bankruptcy, and like Elizabeth said, it's a negotiable fee. I would ask the attorneys, if they can charge a little bit closer to what the lower amounts are, in the 20 to 25% range. That would be my only counsel for it. And you can talk to them about potential caps on expenses too. You have to keep in mind the attorneys need to make their living on doing this, but it's also something where they only get paid if you get paid. But I can assure you that there's a lot of confusion. I was frankly quite surprised how much confusion there is in the community.
Yeah, I think that because again, United Policyholders has a lot of volunteers that are policyholder lawyers, meaning that's all they do. They represent people who are in an insurance dispute, but they only represent the policyholder. Well, obviously, it doesn't pencil out for people to pay somebody by the hour to be their advocate when their problem is that they don't have enough money. So actually, the contingent fee system is the keys to the courthouse for policyholders. It's an incredibly important system. And United Policyholders fights pretty hard to preserve it because, again, the fact that your attorney only gets paid if you get paid means your interests are aligned with theirs. And again, not all lawyers will work on contingency.
Right.
But they will if they believe it's economically viable. And here, clearly, it is. So, Matt, do you want to touch quickly on how, before we get to the compensation categories people can request, just one last thing on hiring an attorney and fees. People are thinking, they're listening to this, and they're thinking, I don't know if I want to put this claim in myself. I think I might like to hire a lawyer. But what would I be looking at in terms of say, expenses and fees, and how do I make that decision?
Well, I think that up front, again, most lawyers that I'm aware of in this case are working on a contingency basis, and it requires no money up front to secure the services of a lawyer. If you have any questions, I think you probably are best served talking to your neighbors and trusted family, friends, and other folks in your situation to find out who they've been working with, who they enjoy working with. Look, we're all on the same team, and we all want the same result, which is to put people back together as whole as possible, recognizing the fact that things will never be the same. and therefore, I think it's not going to cost you any money up front to retain the services of an attorney, and I think it's worth it.
Okay. Elizabeth, again, you've heard a lot of people will say, I'm so tired. I just can't, I just want this to be over.
Right.
Does putting a claim in mean you're going to have to sit for a deposition and you're going to have to turn over your tax returns and, buttloads of documents? Or is this a little bit more straightforward?
This is a little bit more straightforward. These are proofs of claim in a bankruptcy, and what the court will be doing starting on February 18th, 2020, is holding an estimation trial. And that means that the district court, Judge Donato, will be determining overall what the total losses of the fires are for the tort claimants. And experts will be used. There will be modeling. There will be big data. There will be proofs of claim that are used for that. But this is not like an individual lawsuit where by filing a lawsuit, you're opening yourself up to deposition. You're opening yourself up to intrusive examinations of your records or your personal life. This is all about what happened to you, your family, your home, your business, your property, your way of life as a result of these fires. And so these tend to fall into categories. They'll be estimated and dealt with categorically. Judge Donato today in hearing said that he does want to hear from some survivors. He wants personal stories as well as big data, but he doesn't want 100 of those. He doesn't even want 50 of those. He probably wants a dozen or so. And these are folks that will be selected by various attorneys to come forward and stand in for and represent, in terms of stories, what has happened in these fires in order to give the judge who's estimating the total claims the human element here. But that doesn't mean that every one of the tens of thousands of folks that have these fire claims would be called upon to do that. And it doesn't mean that they'd be called upon to do that involuntarily. So I think people can rest assured that filing a proof of claim is something that they can do to empower themselves, to stand up and be counted, to stand up and protect their rights, but it should not be the occasion for more stress and more demand on them as they're trying to put their lives back together. It's something that they can put in a proof of claim, and then it runs in the background as they are continuing to get their lives together. The lawyers will work on these for them. The court will work on these for them. They'll have an opportunity to provide more information potentially. They'll certainly have an opportunity as creditors to vote on a plan of reorganization. By the way, you all, the fires survivors, the victims, get to vote on whether PG&E emerges from bankruptcy and how much it has to pay you in order to do that.
Okay, what we're going to do, we have actually 3 slides with elements of can I claim this, can I claim that. So
Okay.
we hit the hour. We're going to go a little over. I think there's no problem, just a few minutes over if that's all right with you 3.
Absolutely.
Looking at this list, ALE passed October 9th, the cost to hire professional estimators, specialized attorney advisement for coverage during a claim, remainder of contents money, new water line at the fire damaged property, cracked septic tank. Is there anything on that list that you would say is ineligible for compensation in the bankruptcy proceeding? Just right out of the box. Matt, anyone?
We're lawyers. We're going to say that depends. There's a lot of facts. There's a lot of fact-sensitive issues embedded in each one of those bullet points.
All right.
That's right. That's right. So we're hedging. It depends on the individual claim, and it depends on overall reason. By the way, I would say there's something that doesn't show up on that list, and that really wasn't in my in my consciousness until quite recently, but it is a major problem, particularly in the Paradise area, but in some areas of the North Bay too, where property is connected by private roads. Those damage and destruction of those roads is, as I understand it, not insured. It is also not the responsibility of the state or local governments to restore or repair those roads. And so those costs will fall on the property owners if you want access to your property so that you can rebuild, so that you can continue to live there, so that someone you sell it to can access it. That's going to be a cost. And so that would be something that would be worth filing a proof of claim for if your property is accessed by a private road. My understanding is anyone along that road can make that claim for that road, and that's something that the court will have to deal with in terms of estimation and compensation.
And bridges, right? There are a lot of private bridges that were burned in the process as well.
Okay, architect engineering permit costs for detached garage at the new location when the original location did not have a garage. Okay, so this is what you would call in the insurance world betterment, meaning I didn't have it before, I have it now, my insurance didn't want to pay for it. My instinct is something like that's not going to be compensable because but again, I'm not a tort lawyer, so Zach, what would you say there? Again, it depends.
Well, it does, but I would again, on that specific example, the question really is going to come down to whether code required it on the new rebuild or not.
That's right.
If code enforcing the local building codes required the certain architectural engineering or those things for this new detached garage, then I would say yes. If that was the election of the insured to build something different, then I would say probably that aspect of it not.
Okay, so in the beginning of the presentation, I gave a very general slide about basically you could put in or that insurance only covers what insurance covers. So then is it a fair statement to say that everything else that was a loss associated with the fire could potentially be compensable? Not saying people are going to get 100%, but at least to put as if they were going to do it on their own, would you say the general rule of thumb is, how did this fire put you in a worse position than you were before? And that would include things that the insurance company didn't pay for. Is that sort of a fair way to approach it? Would you say? Any of you?
I think that's a fair way to approach it. The boxes on the proof of claim form are not necessarily exclusive. You can write things in specifically or generally if it's something that you believe you have a claim for. Again, your attorney may be able to help you with that. There are some general categories of damages that we will be asking the court to estimate on behalf of the total loss, including punitive and emotional damages. We know that people are filing claims for job loss, for business interruption, and for being unable to work because of the emotional toll of the experience of going through these fires, including PTSD. That's a real claim. People are making that claim. It's a claim that insurance doesn't cover. You don't have an insurance policy for that. You may be getting services and help through your health plan, or you may not. But if that is what has happened to you and it's impacted your life, and it has happened in your, in your own view, because of the fires and what you went through, and you can assert it in good faith, then assert it in good faith. The court will be sorting all of these categories out. They'll be estimating the values of them. I would say, look, don't be unreasonable, but don't censor yourself. There is no moral obligation not to file a claim that is a reasonable claim. I would say there's a moral obligation to file that claim because there is a need here to hold PG&E accountable for all of the damage and all of the loss and all of the harm that it caused to many thousands of people. And this is a do-it-yourself exercise. Victims have to stand up for themselves to do this for themselves and for each other.
Well, Jim, I think I would guess that you have something you want to say about that, because I think that concern is what motivated you to initiate.
Oh, absolutely. I mean, I couldn't agree more. I think fire claimants, the victims, the survivors now, do have to stand up for themselves, and that includes educating themselves about the entire process. I want to say that I think that PG&E probably is responsible for all of these major fires. That's my personal opinion. And that they do reasonably, morally, and ethically, as well as legally, owe all of the fire victims compensation for their uncompensated losses. That is, losses not covered by insurance that are considered reasonable by the court. I think it's a reasonable presumption, actually. I've heard some lawyers talk about this, that anybody that had a significant loss during any of these fires has PTSD, whether they know it or not. And I don't think that's really unreasonable. And my understanding is that the estimation process for emotional damages will be sort of across the board. It'll be in general categories and could be considerable on its own. The other thing is that fire claimants can expect considerable recovery. I mean, my attorney, at least, is saying it's not unreasonable to say recovery will be on average in the 6 digits and 6 figures, and that's on average. So people have a lot of confusion about that. I've even had people on blog sites next door tell me, there's going to be barely enough to, pay your lawyer, and then you're going to have your insurance company pay your insurance company what they paid you, which is not true. They have their own category of collection in this bankruptcy, and there'll be barely enough to go out to dinner. I literally had that told to me, and I've done what I can to dispel that. This is a substantial recovery that could make a real difference in rebuilding your life. And yeah, I feel very strongly that we need to, and I really appreciate United Policyholders for spearheading this, because you guys have been fantastic in helping us. I would be frankly lost. I'm very grateful for the entire process. And I think this is a good use of United Policyholders resources, by the way, Amy, to educate people on the PG&E lawsuit. I think this is a very important component of it.
Well, I really do appreciate the kind words. We are here as a conduit for good information, and I am so grateful. Matt, did you want to add anything to what I kind of am taking from Elizabeth's comments, and then Jim, that basically that it's not on people to do their own math on their PTSD or their emotional distress damages. That's not something that an individual person is going to have to do. Is there, when people are asking you, well, what can I be claiming? Have we left anything out?
I think one thing is I have quite a few friends, clients, even family members of some of my business associates who have young children who have suffered significant PTSD, and to this day, if they smell any bit of smoke, including from a barbecue, they have emotional challenges in those moments. And so it's not just the parent or the adult in the home. You need to be thinking about whether or not everyone in the home, in the household, has a claim. So when that question on the screen, which is who is the creditor, you really want to make sure that you've covered everyone that you can think of within the roof, under the roof, including minor children. And you also need to pay attention, I think, to a lot of people have homes that are owned by living revocable trusts. Are you filing under the right entity, whether it's yourself personally or under your trust? If you are a business owner, don't forget if you might have filed an LLC a while back and forgot about it, and you need to file under the right entity. So you need to make sure that you're keeping that in mind as you figure out who is the current creditor.
Okay, and Elizabeth, to close us out, should we add a monetary value to our claim form if we're doing it on our own?
Take a look at the proof of claim form. That's item number 11. It asks, how much is this claim? And you can insert a dollar value if you know it. That is optional. You can also check unknown to be determined at a later date. So you will always have the opportunity, if you file your proof of claim form, to amend it and to add specificity. There are some things you just aren't going to know the dollar value amount, particularly all of the damages in item 10 of the form, and those include punitive damages. They include non-economic damages, such as emotional distress to yourself or your family members. You know, there's no magic number for those. You're not going to be able to provide, and you won't be held to a specific amount. That's why the court is undergoing a process called estimation, which is taking a look at the whole universe of different types of claims, at the entire areas impacted by the fires, and valuing those on a macro level. So again, this is something for your own decision making. If you consult an attorney, check with your attorney. There may be some items you want to specify. If you have an uninsured loss that's specific, you may want to include that. That would be very helpful for the court to know. And by the way, one of the barriers to filing claims I have heard is people assume that because this is a bankruptcy, this will take years and years. Sometimes bankruptcies do, but this one won't. PG&E is under very strong incentives to emerge from bankruptcy by June 30th of 2020. That's less than a year away. So there will need to be a determination of compensation. There will need to be a plan. There will need to be a system put in place to pay creditors next year, not years from now. So Jim is absolutely right. Some of these claims are very, very substantial, and they are not, they're going to be paid in real time. So that's important.
And again, PG&E is not broke. They filed for reorganization, but there's money there. That's what really, that's the bottom line here.
That's right. When a company is broke, they file for liquidation, they sell everything off, and there's a fight over the remnants. This is not that type of a bankruptcy. Okay. The other thing to remember is your insurance company has taken care of itself already in bankruptcy. You do not need to worry or be concerned about looking out for your insurance company. Your insurance company knows how much it paid you. It has already filed that claim in the bankruptcy. And that's why it's very important for you to file your claim for what you lost and you paid, because the insurance companies, as they have a right to do, have already figured out to the penny exactly how much they've paid out in these fires, and they've put that claim in. That claim will have to be estimated as well, and hopefully discounted so that the tort claimants can be paid appropriately. But as I say, do not worry about looking out for the insurance company. They take care of themselves.
Well, with that, very, very important point, you know, that we're telling you as people who have gone through a very traumatic experience that filing this proof of claim will not be another traumatic experience. It should be pretty straightforward. And so to try to take some of the emotion out, we've presented to you some very important factual information from 3 people that are right in the middle of this, involved in the proceeding, knowledgeable about the proceeding. I'm here to reassure you that you do not need to have a fear that participating in this by filing a claim that you are doing something wrong. You're doing something right for yourself, for your family, for your community. And we very much hope this information will help you continue to move forward on your road to recovery. So thank you for listening. Thank you for sending in your questions. Jim, Matt, Elizabeth, thank you so much for sharing your very, very important expertise with us today.
Thank you, Amy. Thank you for
you.
United Policyholders as well.
Bye-bye. Yes.